I was sitting on my dock watching the sunrise over Lake Tahoe when I first saw the woman marching down the shoreline toward me with a clipboard and what I can only describe as a nuclear-level scowl on her face. This was the moment my peaceful lakefront retirement turned into an absolute nightmare that would drag on for 8 months, cost me thousands of dollars, and ultimately expose a corruption scheme that would make national news. My name is Robert Chen, and I had just moved into my dream waterfront property in the Emerald Bay Estates community on the Nevada side of Lake Tahoe 3 weeks earlier. After 30 years working as a software engineer in San Jose, I had finally saved enough to buy a modest 2-bedroom cabin with direct lake access. The property was not cheap, but I had inherited some money from my late uncle, and combined with my retirement savings, I could just barely afford it. The lake access was the entire reason I bought the place. I grew up swimming and kayaking, and spending my retirement years on the water was all I had dreamed about during those long coding sessions. The woman stopped at the edge of my property, her sensible khaki shorts and polo shirt screaming HOA authority before she even opened her mouth. She was probably in her early 50s, with short blonde hair styled in that particular way that suggests frequent conversations with managers, and she wore oversized sunglasses despite it being barely 7 in the morning. "Excuse me," she called out in a tone that was not actually seeking permission for anything. "I need to speak with you immediately." I stood up from my folding chair, coffee mug still in hand, and walked down the dock toward her. "Good morning. Can I help you?" "I am Sharon Whitmore, president of the Emerald Bay Estates Homeowners Association," she announced, consulting her clipboard. "Are you the new owner of 2847 Lakeshore Drive?" "That's me, Robert Chen. I closed on the property 3 weeks ago." Sharon's mouth formed a tight line. "Well, Mr. Chen, we have a significant problem. I have received multiple complaints from concerned residents about your unauthorized use of the community waterfront." I blinked at her, genuinely confused. "I'm sorry, what? This is my property. The deed clearly shows I own down to the high water mark." She shook her head vigorously, her sunglasses slipping slightly down her nose. "That may be what your deed says, but the HOA has implemented new waterfront access rules as of January 1st this year. All waterfront usage must be approved through the HOA board, and there are designated community access points. Private docks and private lake access are no longer permitted without proper authorization." "That doesn't make any sense," I said, feeling my heart rate start to climb. "I specifically bought this property because of the lake access. That was the entire selling point. The previous owner had a dock here for 15 years. The previous owner sold and moved away, which is precisely why we are implementing these changes," Sharon said, her voice taking on a lecturing quality. "The HOA board determined that unlimited waterfront access was creating safety issues, environmental concerns, and aesthetic problems. We are protecting property values and the community's reputation." I set my coffee mug down on a dock post, trying to process what I was hearing. "So you're telling me I cannot use my own waterfront, the waterfront that I specifically paid a premium for?" "You can use the designated community beach area like everyone else," Sharon said, pointing vaguely up the shoreline. "It is located near the community center, approximately half a mile north. There are specific hours when residents may access the water, and you must reserve time slots during peak season." "This is insane," I said flatly. "I own this property. Lake Tahoe is a public resource. You cannot just ban me from accessing a public lake from my own land." Sharon's expression hardened. "Mr. Chen, I suggest you review your HOA documents more carefully. When you purchased this property, you agreed to abide by all current and future HOA rules and regulations. The waterfront access policy was voted on and approved by the board in December. You are in violation, and if you continue to use this dock or access the lake from this point, you will face fines of $500 per day." $500 per day, I nearly shouted. You cannot be serious. I am completely serious, Sharon said, making a note on her clipboard. I am documenting this conversation and your current violation. I expect this dock to be removed within 14 days, and I expect you to cease all waterfront activity from this access point immediately. You will receive formal written notice by certified mail within 3 business days. She turned on her heel and marched back up the shoreline before I could even formulate a response. I stood there in complete shock, watching her disappear behind the neighboring property. My retirement dream was apparently over before it had even begun. I spent the rest of that morning digging through every document from my home purchase. The HOA disclosure packet I had received during escrow was nearly 200 pages long, and I admit I had not read every single word. Most of it was standard stuff about architectural approval for exterior changes, rules about noise and parking, maintenance fee schedules. But as I went through it page by page, I found absolutely nothing about waterfront restrictions. There was a brief section about community amenities that mentioned a beach area and boat launch, but nothing that suggested private waterfront access would be restricted. I called my real estate agent, Jennifer Martinez, who had helped me buy the property. She sounded surprised when I explained what had happened. "That's really strange, Robert," she said. "I've sold 3 properties in that community over the past 5 years, and waterfront access has always been one of the major selling points. In fact, your property was listed at a premium specifically because of the dock and direct lake access. Let me make some calls and see what I can find out." She called me back 2 hours later, and she sounded troubled. "Okay, so I spoke with the listing agent who represented the seller of your property. He said he had no idea about any waterfront restrictions, and the seller never mentioned anything about it. I also checked with the title company, and the HOA disclosures they received in December did not include any waterfront policy. Something is not adding up here." "So what do I do?" I asked. "I think you need to talk to a lawyer," Jennifer said. "This could be a serious issue. If the HOA implemented a policy that fundamentally changes your property rights after you were already in escrow, that might not be enforceable. Plus, if they didn't properly disclose it, there could be liability issues." I did not want to hire a lawyer 3 weeks into homeownership, but I did not see another choice. I found a real estate attorney in Carson City named David Park who specialized in HOA disputes. His office could see me the following Tuesday. In the meantime, I kept using my dock. I was not going to let Sharon Whitmore and her clipboard intimidate me away from the property I had legally purchased. I went kayaking every morning, and I sat on my dock every evening watching the sunset. If she wanted to fine me $500 a day, she was going to have to take me to court. The certified letter arrived exactly 3 days after Sharon's visit, just as she had promised. It was even more absurd than her verbal warning. The letter outlined the Emerald Bay Estate's waterfront preservation and access policy, which apparently established that all waterfront areas within the HOA boundaries were community resources to be managed collectively for the benefit of all residents. It stated that private docks were visual blight and created environmental hazards. It demanded that I remove my dock within 14 days and cease all lake access from my property immediately. It warned that failure to comply would result in daily fines starting at $500 and increasing to $1,000 after 30 days of non-compliance. The letter was signed by Sharon Whitmore, president, and 2 other board members I had never heard of: Richard Carmichael, vice president, and Patricia Montgomery, treasurer. I brought all of this documentation to my meeting with David Park. He was a sharp-eyed man in his 40s who listened carefully as I explained the situation, occasionally making notes on a legal pad. "This is interesting," he said when I finished. "Very interesting. And you are absolutely certain that this waterfront policy was not included in your HOA disclosures during escrow?" I went through everything page by page, I said. "It is not there. My real estate agent confirmed the title company never received it either. David leaned back in his chair. Here is the thing. HOAs do have broad authority to create and enforce rules, but they cannot unilaterally strip away fundamental property rights that were part of your purchase. Your deed clearly states you own to the high water mark. That is a property right. The HOA can potentially regulate how you use that access. For example, they might be able to set rules about dock size or boat noise, but they cannot completely ban you from accessing a public waterway from your own property. That is what I thought, I said, feeling a wave of relief. So what do we do? First, I am going to send them a letter explaining that their policy is likely unenforceable and potentially illegal, David said. I will cite the relevant Nevada property law and make it clear that you intend to defend your rights. I will also point out that Lake Tahoe falls under the jurisdiction of the Tahoe Regional Planning Agency, and any restrictions on lake access have to comply with TRPA regulations, which generally protect public access to the lake. Will that be enough? I asked. David smiled grimly. Probably not. People who run HOAs like personal fiefdoms usually don't back down from a single letter. But it establishes our position and creates a paper trail. If they want to fine you, they will have to take you to court, and frankly, I don't think they will win. How much is this going to cost me? I asked, dreading the answer. Let's start with the letter and see how they respond, David said. If it goes to court, it could get expensive. HOA litigation can drag on for months or even years, but given the facts here, I think you have a very strong case. And if they are acting in bad faith, we might be able to recover your attorney fees. I authorized David to send the letter. I was still hopeful this could be resolved without a major legal battle. I was a reasonable person. Surely the HOA board would see reason once they understood they were on shaky legal ground. I was very, very wrong. David sent his letter on a Thursday. By Monday morning, I had a response, but not from the HOA's lawyer. Instead, Sharon Whitmore herself called me at 8 in the morning. Mr. Chen, this is Sharon Whitmore, she said without preamble. I received a very concerning letter from your attorney. I am calling to inform you that the HOA board views your continued defiance of our waterfront policy as a serious threat to the community, and we will be pursuing all available remedies, including legal action and substantial fines. Sharon, I think you need to understand that your policy is probably not legal, I said, trying to keep my voice calm. I own my property down to the water. Lake Tahoe is a public resource. You cannot simply ban me from accessing it. That is where you are wrong, she said, and I could hear the smugness in her voice. The HOA has the authority to regulate community resources, and we have determined that waterfront access is a community resource that must be managed centrally. But it is not a community resource, I said, frustration creeping into my tone. It is my private property. Your property ends at the boundary line on your survey, Sharon said. The waterfront itself is a shared resource under HOA management. That is not how property law works, I said. We will see what the court says, Sharon replied. In the meantime, you are now accruing fines of $500 per day. As of this morning, you owe $3,000 for the 6 days you have been in violation since receiving written notice. You cannot be serious, I said. I am always serious about protecting this community, Sharon said. Good day, Mr. Chen. She hung up before I could respond. I immediately called David Park. She is bluffing, David said after I explained the conversation. She is trying to intimidate you into compliance. HOAs do this all the time. They count on homeowners being too scared or too broke to fight back. But here is the thing. Even if they claim you owe fines, they cannot collect them without going through the proper legal process. They would have to get a judgment against you, and no judge is going to uphold these fines given the circumstances. So I just ignore her, I asked. Keep documenting everything, David said. Take photos of your dock and waterfront. Keep records of every time you use it. Save all communications from the HOA. And yes, ignore the fine notices. When they realize you are not backing down, they will either give up or they will have to sue you, and if they sue you, we will countersue for harassment and violation of your property rights. I followed David's advice. I kept using my dock, I kept kayaking, and I kept enjoying the property I had purchased. But the harassment from Sharon Whitmore did not stop. Over the next 2 weeks, I received 3 more certified letters, each with increasingly aggressive language and escalating fine amounts. According to Sharon's calculations, I now owed over $15,000. Then things got weird. I came home from a grocery run on a Wednesday afternoon to find a man in a contractor's vest taking photographs of my dock. He had a professional camera with a long lens and was documenting every angle. "Excuse me," I called out as I got out of my car. "What are you doing?" The man looked startled. "I am with Mountain Vista Inspections. The HOA hired us to document code violations." "Code violations," I repeated. "What code violations?" "The dock, sir," he said, consulting a clipboard. Of course it was a clipboard. "I am documenting that it is still present despite the removal order." "That dock is on my private property," I said. "The HOA has no authority to order its removal." The man shrugged uncomfortably. "I just take the photos, sir. You would have to talk to the HOA about the rest." He finished his documentation and left. I called David Park again. "They are building a case," David said. "They are going to use those photos as evidence of your non-compliance." This is actually good news in a way. It means they are planning to take formal action, which means we will get our day in court. "I just want to use my dock," I said wearily. "I did not sign up for this." "I know," David said sympathetically. "Unfortunately, HOA disputes can get ugly. But hang in there, we are going to fight this." The formal lawsuit came 2 weeks later. The Emerald Bay Estates Homeowners Association filed a complaint in Washoe County District Court seeking an injunction to bar me from using my waterfront, an order requiring me to remove my dock, and payment of over $25,000 in accumulated fines. David filed a response denying all of their claims and a counterclaim alleging that the HOA had violated my property rights, failed to properly disclose their waterfront policy, and engaged in harassment. We asked the court to declare the waterfront policy unenforceable and award us attorney fees. The case was assigned to Judge Margaret Holloway, who scheduled a preliminary hearing for 6 weeks out. In the meantime, David filed a motion asking the court to issue a temporary order preventing the HOA from enforcing their waterfront policy until the case could be fully heard. During this entire process, I kept learning more about Sharon Whitmore and the HOA board, and none of it was reassuring. I started talking to other residents in the community, and I discovered that Sharon's waterfront policy was deeply unpopular with almost everyone except her inner circle on the board. A neighbor named Tom Bradshaw, who lived 4 houses down, came by one evening with a 6-pack of beer and some information. "I heard you are fighting Sharon on the waterfront thing," he said as we sat on my dock watching the sun set over the lake. "Good. Someone needs to stand up to her." "You do not agree with the policy?" I asked. Tom snorted. "Nobody agrees with it except Sharon and her cronies. The whole thing was rammed through in a special board meeting in December when half the community was gone for the holidays. Only about 15 people showed up, mostly her friends. They voted it through and the rest of us did not even know about it until we got the notice in January." "Why would she do this?" I asked. "What is the point?" Tom took a long drink of his beer. "Control. Sharon loves control. She has been HOA president for 6 years, and every year she comes up with new rules to micromanage everyone's lives. Last year, it was restrictions on exterior paint colors. The year before that, it was rules about where you could park in your own driveway. This waterfront thing is just the latest power trip. But it affects her too, right?" I said. "I mean, if she lives in this community, she is giving up her own waterfront access." Tom gave me a strange look. "You do not know?" "Know what? Sharon does not have waterfront property," Tom said. She lives up on the hill in one of the interior lots. She bought in 8 years ago thinking it was a good investment, but then she realized all the expensive properties are on the water and hers was never going to appreciate the way she hoped. Ever since then, she has been bitter about it. This waterfront policy is her way of punishing everyone who has what she does not. That explained a lot. This was not about environmental protection or safety or community values. This was about jealousy and spite. "There is something else you should know," Tom said, lowering his voice even though we were alone. "Sharon and the board have been talking about selling off the community beach area to a developer. There is a company that wants to build a private marina and charge membership fees. Rumor is Sharon and the other board members would get kickbacks from the deal." "That is corruption," I said flatly. "That is Sharon," Tom replied, "but nobody has been able to prove it. She keeps all the board meetings closed and she controls all the financial records." A few people tried to challenge her last year during the board elections, but she got them disqualified on technicalities. "This is insane," I said. "Welcome to Emerald Bay Estates," Tom said, raising his beer in a mock toast. Armed with this new information, I told David everything Tom had told me. David's eyes lit up. "If we can prove that the board members have a financial interest in restricting private waterfront access, that changes everything," he said. "That would be a breach of fiduciary duty. Board members cannot use their authority to enrich themselves at the expense of homeowners." "How do we prove it?" I asked. "We need to see the HOA financial records and meeting minutes," David said. "As a homeowner, you have a legal right to inspect those documents. Let me draft a formal request." David sent a letter to Sharon Whitmore requesting access to all HOA financial records, board meeting minutes, and correspondence related to the waterfront policy and any potential sale or development of community property. The HOA had 15 days to respond under Nevada law. Sharon waited until day 14 to respond, and her answer was exactly what we expected: denied. She claimed the documents contained privileged information and that releasing them would violate the privacy rights of other homeowners. "That is not how this works," David said when he received her response. "She cannot just refuse. We will file a motion to compel production of the documents. Before we could file the motion, something unexpected happened. I got a knock on my door at 9 o'clock on a Friday night. When I opened it, I found a woman in her 30s standing there looking nervous. 'Mr. Chen,' she said. 'My name is Amanda Reeves. I am the HOA secretary. Can I talk to you for a minute?' I invited her in, curious. Amanda sat down on my couch and immediately started talking fast, like she needed to get everything out before she lost her nerve. "I need to tell you what is really going on," she said. "Sharon and Richard Carmichael have been planning this for months. There is a development company called Tahoe Luxury Properties that wants to buy the community beach area and build a private marina and club. They have offered the HOA $2 million for the land. But here is the thing. Sharon and Richard set up a separate LLC called Bay Management Solutions. If the sale goes through, Tahoe Luxury Properties will pay Bay Management Solutions a consulting fee of $400,000, supposedly for project management services. But it is really just a kickback. Do you have proof of this?" I asked. Amanda pulled a flash drive from her pocket. "I am the secretary, so I have access to all the board files. I made copies of everything. The LLC documents, the emails between Sharon and the developer, the draft contracts. It is all here. I probably should not be doing this, but this is wrong. Sharon is stealing from the community and she is destroying people's property rights to do it." I took the flash drive carefully. "Why are you coming forward now?" "Because you are fighting back," Amanda said. "Everyone else has been too scared. Sharon threatens people, she drives them out of the community. But you are actually standing up to her and I think you might actually win. I want to help." "Does Sharon know you are here?" I asked. Amanda shook her head. "No. And I need you to promise you will not tell her where you got this information, at least not until your lawyer has everything filed with the court. I cannot afford to lose my position on the board right now. I have my own reasons for needing to stay." "I promise," I said, "and thank you." This might make all the difference. After Amanda left, I immediately called David Park, even though it was almost 10 at night. He told me to bring the flash drive to his office first thing Monday morning. That weekend felt endless. I kept expecting Sharon to show up at my door, somehow knowing that Amanda had given me the documents. But nothing happened. I went kayaking both mornings, I worked in my garden, I tried to act normal. Monday morning, I was at David's office when he unlocked the door at 8. We spent the next 3 hours going through everything on Amanda's flash drive, and it was even worse than she had described. The documents showed that Sharon and Richard had not only set up the LLC for the kickback scheme, but they had also been inflating HOA maintenance fees for years and funneling the extra money into personal accounts. They had billed the HOA for services that were never performed, using fake invoices from companies they controlled. The waterfront policy was just the final piece of the puzzle, artificially devaluing the waterfront properties while simultaneously making the community beach area more valuable to developers by eliminating competition from private docks. "This is fraud," David said, his voice tight with controlled anger. "This is embezzlement. This is criminal." "What do we do?" I asked. "First, we file an emergency motion with the court," David said. "We present this evidence and ask Judge Holloway to issue an immediate injunction against the HOA board, freezing their authority until a full investigation can be completed. Then we report this to the district attorney. This is not just a civil matter anymore. Sharon Whitmore and Richard Carmichael need to be prosecuted." David worked all day Monday and Tuesday preparing the motion. On Wednesday morning, we filed it with the court along with copies of all the documents from Amanda's flash drive. We also sent a copy to the Washoe County District Attorney's office. Judge Holloway scheduled an emergency hearing for Friday afternoon. I will never forget walking into that courtroom. Sharon Whitmore was there with the HOA's attorney, a slick-looking guy in an expensive suit named Gerald Preston. Sharon looked supremely confident, like she had already won. She barely glanced at me as I sat down next to David at the plaintiff's table. Judge Holloway was a no-nonsense woman in her 60s with gray hair and sharp eyes. She called the hearing to order and asked David to present his motion. David stood and delivered a crisp, devastating summary of what we had discovered. He presented the evidence of the LLC, the kickback scheme, the embezzlement, and the fraudulent waterfront policy. He explained how Sharon and Richard had violated their fiduciary duties and used their positions to enrich themselves at the expense of the homeowners. He asked the court to immediately enjoin the HOA from enforcing the waterfront policy and to remove Sharon and Richard from the board pending a full investigation. Gerald Preston tried to object, claiming the documents were obtained improperly, but Judge Holloway cut him off. "Mr. Preston, these appear to be official HOA documents," she said. "Are you claiming they are fake?" "No, Your Honor, but—" "Then their authenticity is not in question," Judge Holloway said. "The question is what they reveal, and frankly, what I am seeing here is deeply troubling." She turned to Sharon. "Miss Whitmore, did you and Vice President Carmichael establish an LLC called Bay Management Solutions?" Sharon's face had gone pale. "Your Honor, that is a separate business entity that has nothing to do with, did you establish it or not?" Judge Holloway interrupted. "Yes, but—" "And is it true that this LLC would receive a payment of $400,000 if the community beach area is sold to Tahoe Luxury Properties?" Sharon looked at her attorney desperately. Gerald Preston stood up. "Your Honor, we would need time to review these documents and prepare a proper response." "I am sure you would," Judge Holloway said dryly. "Unfortunately for you, Mr. Chen has a right to use his property, and based on what I am seeing here, the HOA has engaged in what appears to be fraud to deprive him of that right." She shuffled through the papers in front of her. I am granting the emergency motion. The Emerald Bay Estates HOA is hereby enjoined from enforcing its waterfront access policy against any homeowner. Mr. Chen is free to use his dock and waterfront without restriction. Furthermore, I am removing Sharon Whitmore and Richard Carmichael from the HOA board effective immediately, pending a full forensic audit of the HOA's finances. Patricia Montgomery will serve as interim president. Sharon shot to her feet. You cannot do that. I was elected by the homeowners. Sit down, Miss Whitmore, Judge Holloway said coldly. You are in enough trouble already. I suggest you consult with your attorney about the criminal implications of what you have done. This hearing is adjourned. The gavel came down with a sharp crack that seemed to echo through the courtroom. Sharon stood frozen, her face a mask of rage and disbelief. Gerald Preston was frantically whispering to her, probably telling her to keep her mouth shut. Richard Carmichael, who had been sitting in the gallery, looked like he was about to throw up. David and I walked out of the courtroom into the bright Nevada afternoon. I felt like I could breathe for the first time in weeks. We won, I said, still hardly believing it. We won this round, David said, but this is not over. The criminal investigation is just beginning, and we still have the civil case to resolve. But yes, this was a very good day. The criminal investigation moved faster than I expected. The Washoe County District Attorney's Office assigned a prosecutor named Sarah Mitchell to the case. She called me the following week to ask if I would be willing to testify before a grand jury. I said yes, without hesitation. The forensic audit of the HOA finances took 6 weeks and revealed even more fraud than we had initially discovered. Sharon and Richard had embezzled over $300,000 from the HOA over a 4-year period through fake invoices, inflated maintenance contracts, and unauthorized payments to their personal accounts. The waterfront policy was part of a scheme to sell community assets and pocket the proceeds through their LLC. In late July, Sharon Whitmore and Richard Carmichael were indicted on multiple counts of fraud, embezzlement, and breach of fiduciary duty. They were both arrested on a Thursday morning. I heard about it from Tom Bradshaw, who called me with barely contained glee. They just took Sharon away in handcuffs, he said. There are cops all over her house. This is the best day of my life. I felt a grim satisfaction, but mostly I just felt tired. The whole ordeal had consumed 6 months of my life. I just wanted to move on. The criminal trial took place in October. I testified about how Sharon had tried to ban me from my waterfront and the fake reasons she had given for the policy. Amanda Reeves also testified, explaining how Sharon had manipulated board meetings and hidden financial information from homeowners. The prosecution presented mountains of documentary evidence showing the fraud and embezzlement. Sharon and Richard's defense was essentially that they had been trying to protect the community and any financial irregularities were just accounting errors. The jury did not buy it. After 3 days of deliberation, they returned guilty verdicts on all counts. Sharon Whitmore was sentenced to 4 years in federal prison and ordered to pay full restitution of over $300,000. Richard Carmichael got 3 years and was jointly liable for the restitution. Both were also permanently banned from serving on any HOA board in Nevada. The civil case settled shortly after the criminal verdicts came down. The HOA agreed to pay my attorney fees, which totaled nearly $40,000. They also formally rescinded the waterfront access policy and issued a written apology to all homeowners. Patricia Montgomery, the new permanent HOA president, turned out to be reasonable and competent. She implemented new financial controls and transparency measures to prevent future fraud. As for me, I finally got to enjoy my retirement in peace. I spent my mornings kayaking on Lake Tahoe, watching the sun rise over the mountains. I spent my evenings sitting on my dock, reading books and listening to the water lap against the posts. Tom Bradshaw became a good friend, and we started a tradition of Friday evening dock beers. The story made local news and even got picked up by a few national outlets as an example of HOA corruption. I did a couple of interviews, mostly because I wanted people to understand how important it is to stand up to bullies, even when they have official titles and clipboards. One of the things I learned from this whole experience is that property rights matter. They matter a lot. When you own land, especially waterfront land, you are not just buying a piece of dirt. You are buying access to natural resources that belong to everyone. Lakes, rivers, oceans, these are public resources. No private organization should be able to cut you off from them, especially when your own property deed guarantees you that access. The legal principle that ultimately won my case was something called the public trust doctrine. It is an old concept, going back to Roman law, that says certain natural resources are preserved for public use and cannot be privatized. In most states, including Nevada, navigable waters fall under this doctrine. That means even though I own my waterfront property, the lake itself belongs to the public, and I have a right to access it. The HOA could not take that away from me without violating both my property rights and the public's right to the water. David Park explained all of this to me after the case was over. The thing about water rights is that they are really well established in Western law, he said. States like Nevada take them very seriously because water is such a precious resource out here. Sharon probably thought she could bully you into compliance before you figured out the law was on your side. She didn't count on you fighting back. I almost did not fight back, I admitted. If those fines had been real, if she could have actually collected them, I might have given up. I do not have unlimited money. That is what people like Sharon count on, David said. They use fear and intimidation because most people cannot afford to fight. That is why cases like yours are so important. You expose the fraud, and now hundreds of homeowners in that community are protected. In the months after the trial, I learned more about just how widespread HOA abuse is in America. There are over 370,000 HOAs nationwide, governing more than 40 million people. Most of them function reasonably well, but thousands of them are run by power-hungry people like Sharon Whitmore, who use their positions to harass and control their neighbors. The problem is that most homeowners do not know their rights, and they cannot afford lawyers to defend them. I started getting contacted by other people facing similar situations. A man in Florida whose HOA tried to ban him from his dock. A woman in Arizona whose HOA claimed ownership of her backyard because it bordered a community wash. A couple in North Carolina whose HOA tried to charge them access fees to use the beach in front of their own property. I could not help all of them, but I tried to offer advice and connect them with resources. The other thing this experience taught me was to read every single document before buying property in an HOA community. I mean every single page. If I had been more careful during my purchase, I might have spotted some red flags about how the Emerald Bay Estates HOA was being run. There might have been clues in the financial statements or the board meeting minutes. I was so excited about the property itself that I did not do my due diligence on the organization that would have power over it. My advice to anyone considering buying in an HOA community is this. First, request several years of board meeting minutes and read them carefully. Look for patterns of conflict, arbitrary rule enforcement, or unusual financial transactions. Second, talk to current homeowners and ask them directly what they think of the HOA. Do not just talk to one person, talk to several and see if you hear consistent themes. Third, review the HOA's financial statements and look for anything unusual, like payments to companies you cannot identify or expenses that seem inflated. Fourth, check if the HOA has been involved in lawsuits. This is public record and it can tell you a lot about how the organization operates. If you already live in an HOA and you are facing abuse, document everything. Save every email, every letter, every violation notice. Take photos and videos. Build a paper trail. If the HOA is violating your rights, you will need evidence to prove it. and do not be afraid to hire a lawyer. Yes, it is expensive, but your property rights are worth defending. In many cases, if the HOA is acting in bad faith, you can recover your attorney fees. Also, get involved in your HOA. Go to board meetings. Run for the board yourself if you can. Most HOA problems happen because the reasonable people check out and let the petty tyrants take over. If good people participate, most HOAs function fine. The Emerald Bay Estates community is much better now. Patricia Montgomery runs a transparent board that actually serves homeowners instead of exploiting them. They publish financial statements quarterly. They hold open meetings where residents can raise concerns. They even established a waterfront committee to address legitimate environmental and safety issues cooperatively instead of through dictatorial bans. Tom Bradshaw ran for the board in the first election after Sharon's removal and won easily. He now serves as vice president, and he is passionate about preventing future abuse. He helped rewrite the HOA bylaws to include term limits for board members and to require supermajority votes for any policy that affects property rights. Amanda Reeves left the board after Sharon's arrest. She told me she had only joined initially to keep an eye on Sharon because she suspected something was wrong. Once the fraud was exposed and real leadership was in place, she felt comfortable stepping away. I remained grateful to her for having the courage to come forward. Without her evidence, I might still be fighting the case. As for Sharon Whitmore, I honestly tried not to think about her much. She was serving her time in a federal facility in California. According to news reports, she maintained her innocence and blamed everyone else for her downfall, me included. Some people never learn. Richard Carmichael quietly served his sentence and then moved out of state after his release. I heard he went to live with family in Oregon. Patricia Montgomery told me that he actually showed some remorse toward the end, unlike Sharon, but the damage he helped cause was still severe. The Tahoe luxury properties development deal fell apart completely once the fraud was exposed. It turned out that their entire business model depended on getting the community beach area at a below-market price through the corrupt HOA board. Once they had to negotiate with a legitimate board at fair market value, they lost interest. The community beach area remains community property, and it is better maintained now than it ever was under Sharon's regime. I settled into a comfortable routine over the following year. I made friends with several other residents who appreciated what I had done to expose the corruption. A few of them had been thinking about leaving the community because of Sharon's harassment, but they stayed after she was removed. The property values actually increased once word got out that the HOA was now well-managed and scandal-free. I took up fishing, something I had not done since I was a kid. Tom taught me the good spots on the lake for trout. We would head out early in the morning when the water was still and glass-like and just drift and talk and cast our lines. Those mornings became some of my favorite times. I also started volunteering with a nonprofit organization called the Homeowners' Rights Alliance. They provided legal resources and education to people facing HOA abuse. I shared my story at several of their events, and I helped connect people with attorneys who specialized in these cases. It felt good to turn my awful experience into something that could help others. Looking back on everything, I sometimes wondered what would have happened if I had just given up when Sharon first confronted me on that morning in early spring. What if I had said, okay, fine, I will use the community beach area. I will remove my dock. I will accept that I wasted my money on waterfront property I could not actually use. Sharon and Richard would probably still be running their scam. They would have sold off the community beach area and pocketed their kickback. Other homeowners would have continued being victimized, but I did not give up, and that made all the difference. The fundamental question in my case was simple: who owns the lake? Or more precisely, who has the right to access the lake? Sharon Whitmore thought she could answer that question through force and intimidation. She thought that having a title and a clipboard and the backing of an HOA board gave her the authority to override property rights and restrict access to a public resource. She was wrong. The lake does not belong to the HOA. It does not belong to any private organization. Lakes are public resources held in trust for all the people. My property gave me the legal right to access that public resource, and no HOA policy could take that away. This principle extends beyond just lakes. Rivers, streams, ocean beaches. These are all generally protected as public resources under the public trust doctrine. There are variations from state to state in how this doctrine is applied, but the core principle is consistent. Certain natural resources are too important to be privatized and must remain accessible to the public. When HOAs or other private organizations try to restrict access to these resources, they are not just violating individual property rights, they are threatening a fundamental public good. This is why my case mattered beyond just my own situation. It was a reminder that we all have a stake in protecting public access to natural resources. I heard from several environmental organizations after my case made the news. They were interested in the legal precedent it might set for protecting lake access in HOA communities. One group, the Lake Tahoe Access Coalition, even used my case as an example in their advocacy work to preserve public access points around the entire lake. I never expected to become an environmental advocate, but I was happy to help however I could. In the end, my dream retirement was just delayed, not destroyed. I got to keep my dock, my waterfront access, and my piece of paradise. I made good friends, I stood up to corruption, and I helped protect the rights of my neighbors. I paid a price in stress and legal bills, but it was worth it. Every morning when I carry my kayak down to the dock and push off into the clear blue water of Lake Tahoe, I am grateful. I am grateful for the courage to fight back. I am grateful for the legal system that ultimately worked correctly. I am grateful for people like Amanda Reeves and Tom Bradshaw and David Park who helped me along the way. And I am grateful for the lake itself, this magnificent public resource that no petty tyrant can ever truly control. Sharon Whitmore tried to ban me from my own waterfront, but she made a huge legal mistake. She forgot that some rights are so fundamental they cannot be taken away by clipboard warriors and fraudulent HOA policies. Property rights matter. Public access to natural resources matters. Standing up to bullies matters. I am Robert Chen, I live on Lake Tahoe, and I won.